All right, Chancellor Weaver, do you want to start or would you like me to start?
I'd like for you to start, Judge Davis.
That's so generous of you. Ladies first, right?
Thank you.
Okay, guys. Thank you all for tuning in. So I kind of view this as just sort of my informal thoughts on things that I wish I had known or tips that I think can help you as you start your legal career. My perspective, of course, comes from the time that I had in private practice and then the past 6 years that I have spent as a circuit court judge. I've been in my new role with the Court of Appeals for exactly 4 days. So I do not have any tips that are particular to appellate work. Y'all can check back with me in a year or so, and maybe I'll have some tips from that perspective. But for now, it'll be based on primarily the years that I've spent as a circuit court judge. So I kind of made a list of just some thoughts and some things that I think helped me along the way and that I think might be important for you. And of course, we'll have a time for question and answer. And please don't hesitate to ask any question that you have. There is no dumb question. There's no question that's too easy or too simple. I know Chancellor Weaver and I are more than happy to answer whatever questions you have on whatever topic that we can. So my first tip is this, and that is, it's okay to be uncomfortable with where you are. I feel like the first 3 years as a new practitioner are difficult. They just are. You're in this new career. You've just graduated from law school, which taught you a lot of great things, but some of the practical things, like where is the clerk's office? Where do I go to file something? Where is the judge's office? Things like that are just things you have to learn on the job training. And so it's okay if you don't know the answer to something. That's to be expected. So don't beat yourself up because you don't know something and because you're uncomfortable not knowing something. I spent the first 3 years of my practice being very uncomfortable because I saw things I had never seen before. I dealt with issues I had never dealt before. But as time goes on, you will see that things start to repeat themselves and you start to have some comfort with, okay, yes, I've done this before. I have drafted interrogatories and requests for production before. I can do that again. I just need to fine tune them. So it just takes time for you to get those things under your belt to where you start feeling comfortable. So be okay with being uncomfortable is my first tip. The second thing I would say is, it's very important for you as a new lawyer to become familiar with and become friendly with the people who are really in charge of the court system. That is not me, and that is not Chancellor Weaver. That is our assistant, and that is the folks in the clerk's office. They really are kind of the day-to-day folks who really operate. They run the wheels over there, and they can be allies to you if you are nice to them. So if you have not met the folks in your clerk's office, wherever you're practicing, if you're in Knox County, you may be in a different county. You may be in Chancery, you may be in Circuit, you may be in Court of Appeals, you may be over in criminal, juvenile, wherever you are. Make it a point to introduce yourself to those folks in the clerk's office. Tell them who you are, tell them what you do, tell them you just graduated. They're super nice. They're all super helpful. And you will do yourself a favor if you get to know those people because they can they can tell you things. They can give you information. They're the gatekeepers to the judges. And I will also tell you a little secret. They let us know when people are behaving and when they are not behaving. So, for example, if you've got an order due and you were supposed to have it to me by a certain date and you don't, I'm not the one keeping up with that. My assistant, who used to be Judy, she was the one who kept up with that. So she was the one that would make those phone calls and say, hey, when's this order coming? And so if you tell Judy that order is coming in a week and the order doesn't come in a week and she has to stay on you to get the orders in, I hear about it. And so we have a little list of our special friends that we have to stay on because they don't do what they told us they were going to. And Don't think that I don't hear that from my assistant, and Chancellor Reaver does not hear that from his assistant, because we do. So get to know those people, treat them right, respond to them when they call you, and do what you tell them that you're going to do. All right, local rules are very important. So please make sure you read the local rules. They vary from county to county, and they can be very specific, and they can be different. So make sure whenever you are taking on a new case that you go back and read those local rules for that particular jurisdiction that you're in, so that you know specifically what you should and should not do. For example, in Knox County in Circuit Court, we have a local rule on motions to compel discovery responses. So let's say that your adversary was supposed to respond to your interrogatories and didn't do it within the 30 days, and you file a motion to compel. Those motions are automatically granted with after 10 days if no response is filed. So when you file your motion to compel, you're supposed to file with it an order. That order gets held for 10 days. If no response is filed, I will automatically sign that order. You need to know that if you're filing the motion yourself, because you need to know that you need to attach the order to it. And you also need to know that if you are on the other side, you need to know that if the motion to compel is filed against you, that you've got 10 days. And if you don't respond within that 10 days, for example, there may be some reason why you haven't responded to the discovery request. You may have an objection to them, or a motion to quash, whatever. If you don't file that within those 10 days, then it doesn't matter. The order is going to get granted, and you're going to have to respond anyway. So it's important to familiarize yourself with those local rules. So always make sure that you do that. The other piece of advice that I have, it's hard to do it in this particular area, this particular time where we are now with everything going on with COVID, because we don't have the in-person things like we used to. But when those things start back up, it's really valuable to watch as many court proceedings as you can if you are going to be a litigator. Back in the day when we held in-person motion hearings, I would encourage new lawyers, even if you don't have a motion on the docket, if you've got an hour that you can spare on a Friday morning when a motion docket is being heard, just go and watch. And that way you're familiar with the process, how cases are called, where the attorneys sit, just kind of what goes on a motion day. And same thing, for example, if you're in criminal court or if you're in general sessions court, if you can just go and spend some time watching a docket, you're going to feel so much more comfortable when it's your turn to actually be there and present your motion or present your case. Everything won't be completely foreign to you if you've had an opportunity to go and watch. So it is my sincere hope and belief that we will at some point get back to having things in person. And when that happens, I would encourage you to go and watch as many things as you can. The other piece of, and I've got like 5 or 6 different things here, and I'm heading towards the end, Chancellor Weaver. If you're wondering if you're ever going to get to talk, yes, I'm almost done.
Come on, Judge.
All right. Marcia will be glad to hear. Okay, Marcia will be glad to hear this piece of advice, and that is to become active in bar association activities, and particularly barristers for new lawyers. And I say new lawyers because it doesn't mean necessarily young lawyers, because we know that not everybody goes to school, to law school right after they graduate from college. So to be in the barristers doesn't mean that you have to be a certain age. It just means that you have to be a new lawyer, newly admitted. And I can't remember how many years it is that you are eligible to be barristers, but that's where you want to go to become involved in bar activities. It is so invaluable because you get to meet, number one, all of your colleagues. These are the people that you will see on the other sides of your cases sometimes. And to meet them and get to know them in a social capacity, in an informal environment like that, makes it a little less stressful when you know the person on the other side of the case. So just familiarizing yourself with your friends in the bar is number one. And number two, it's just so many opportunities to learn. The CLEs that the KBA provides are tremendous. I mean, there's a CLE that you could participate in just about every week if you wanted to. And everything is also online now. So just opportunities to develop your professional practice, get to know your colleagues, become involved in pro bono activities, Habitat for You. I mean, just there's so many things you can do as a member of the bar. I can't stress enough that to me, that's one of the most important things that you can do as a new lawyer. Okay, a couple more points that I have that people taught me along the road. One of our partners at Hodges, Dowdy and Carson, Bob Campbell, who is one of the giants of the Knoxville legal community. He's been retired for many years now, but just a tremendous lawyer and so well respected. He always said that when you come into work each day, do the hardest thing first. So if you've got a phone call that you're dreading to make, that you've got a difficult conversation that you need to have, or you have an issue that you're struggling with that you need to research, or you've got something, an email that you need to send out that you don't really look forward to doing that. Tackle that project first, because otherwise you spend all day doing other tasks, having that dreaded task in the back of your mind, and it just kind of puts a damper on your whole day to spend your whole day like that. So when you get into work, do the most difficult task first, get it out of the way, and then move on to the things that you are going to find more enjoyable. All right, two more things. And these are, I think, kind of the most important, and they kind of go hand in hand. And that is, don't confuse being a zealous advocate with being a jerk. All right. A lot of times people feel like in order to adequately and properly represent their clients, that means that they have to be adversarial 100% of the time, even when dealing with opposing counsel on simple matters. Everything is a battle. Everything is a fight. That is so not necessary. It is not a required way to practice law and effectively represent your client. And a lot of times it can do just the opposite, because what happens is you develop a terrible reputation with the other members of the bar. And that leads to my second and sort of last point that I wanted to make, which is guard your reputation zealously. You guys, if you're at the start of your legal career, you're coming in fresh and you're coming in with a blank slate. So the judges don't know you, the other lawyers don't know you, and the only way they're going to get to know you is by the way you handle yourself in the cases that you have. And so you can kind of go one or two routes. You can be one of those lawyers that never returns phone calls, that is like pulling teeth to get a response to an email. You can be one of those lawyers who will never agree to a continuance, who will never agree to a few extra days to answer discovery requests. You can be one of those lawyers who takes a nasty tone every time you speak to them or send them an email. You can do that. You can be that way. And there are lawyers in this community. Fortunately, there's not a lot of them, but there are lawyers that way, and everybody knows who they are. Nobody enjoys having cases with them. And they're not any more effective as an advocate than someone who chooses to go the other way, which is to understand that we are all, as lawyers, in a difficult role. It's a stressful career. It's battling every day. You take a case, you've got two different sides, and they are in a battle with each other. But just because that is the case doesn't mean that we as advocates have to take on that same animosity that our clients have when we're dealing with each other. So, to the extent that you can be accommodating with opposing counsel, do so. It doesn't hurt your case. It doesn't hurt your client. It's not going to hurt your client to give your opposing counsel 5 more days to answer discovery requests. It'll be okay. And I understand it's a challenge because sometimes clients have expectations about how they think their lawyers should behave in order to be effective advocates. I mean, you see clients specifically I want a bulldog lawyer, somebody who's going to fight, somebody who's going to really stand up and go to bat for me. And so some of that is educating your client on what it means to be an effective advocate. That doesn't necessarily mean that you have to fight everything tooth and nail on things that can be agreed upon. So, be the lawyer that is responsive to the court, be the lawyer that does things on time when you say you're going to do them. Be the lawyer that you know if you have to call them and you need something, they're not going to fight you for no reason on it. Those are the lawyers that enjoy the good reputations. This, of course, is on top of just making sure that you're a good advocate in general, that the arguments that you make are sound, and that you're not throwing things out there that are not good arguments and not good lawyering. So just behave, I guess, is the short way of saying that. Treat your fellow attorneys the way that you would hope to be treated if what you were asking for was on the other side. And if you do those things, I think you will find that before you know it, a couple of years have passed and you've gained some comfort with what you're doing. You have some confidence in what you're doing. You feel good about, where you are as a growing lawyer, growing your skills and becoming an established member of the bar. And I think you will find that this profession, while very stressful, is also very fun and very rewarding, and is filled primarily with really good people who are just trying to do good work for their clients. So that's my kind of hit 'em and quit 'em in a nutshell tips. So I will turn it over to you, Chancellor Weaver, for thoughts that you may have.
Well, I think that everything that Judge Davis said applies to the young lawyer in Chancery Court or Circuit Court. But what I remember back when I first was starting out, no one ever explained to me at all really what the difference was, Chancery Court, Circuit Court. And with Chancery Court, the main difference is it's mainly oriented toward bench trials, whereas there are a lot of bench trials where Judge Davis was previously the judge, but we think of it as being oriented toward jury trials. And as lawyers, we think in terms of judges, juries, attorneys, witnesses. But Chancery Court is different in the sense that most of it is toward bench trials with just the lawyers, the judges, and the witnesses. How that came about is that the jury system back in Old England was directed mainly toward awarding money through the jury system, through using juries. And that often turned out to be unfair because the legal system was so limited. There were just a few claims that could be brought, and even less defenses. The main two defenses were denying it or something similar to a 12-2-6 motion. And for instance, the defense of fraud was not recognized. So if a contract action was brought in Old England with the jury system, a defrauded purchaser could never win the case. So what happened was the law court started sending these people to the king to get him to right the wrong, get him to do whatever justice he thought should be done. And then he started sending them to the chancellor, and then the chancellor to the deputy chancellors, and then Chancery Court's born back in the 1300s. But the main difference today is that orientation has still remained somewhat in place, at least in Knox County, probably Delaware, Mississippi. And that is, most of our jury trials are done in Circuit Court, not in Chancery Court. In Chancery Court, of 5,200 cases a year, maybe 2 might be jury trials. So it's a little bit different of an orientation. Chancery Court, we had originally the cases that went to Chancery Court, originally that went to the king, those were known as equity cases. So that's how come you hear us referred to often as the equity court. Those equity cases, well, let me give you some examples of them. They're still around today. They're accidents and cases from accidents and mistakes, fraud cases, trust cases, specific performance cases, accountings, if you ask for an accounting, winding up partnerships, actions for enforcing liens, actions by wards against their guardians or conservators, actions pertaining to the administration of estates, things of that nature. Those are equity cases. There are a lot more, but I won't go into all of them. But one thing in particular that you might be aware of as a young lawyer is originally Chancery Court only had jurisdiction over equity cases. Then back in the middle part of the 19th century, Chancery was given concurrent jurisdiction with Circuit Court over Circuit court cases accept torts for unliquidated damages. Maybe good examples would be car wrecks and medical malpractice cases. But here's a quirk, though, and that quirk is circuit court was not given jurisdiction over equity cases. So that distinction is still there, but it usually doesn't ever come up as a problem. And be aware of this as a young lawyer. If somebody raises it as a problem, that by statute, you can have the case transferred if necessary, or if there's no objection, the circuit court can keep an equity case and hear it, or the chancery court can keep a law case and hear it, or one of these cases for a tort for unliquidated damages. Now, when you come and visit Chancery Court, as opposed to where Judge Davis formerly was down in Circuit Court, you'll notice that our clerk is called a clerk and master. And the reason for that is that the clerk and master sits here somewhat like a magistrate does in, say, federal court, because he can often hear cases as a master and reports back to the chancellors as to his recommendations. In the probate part of our jurisdiction, and Chancery Court has jurisdiction over probate cases and administration of decedents' estates, the clerk and master hears the initial level of those cases, most of them, all of them except for will contests, solemn form probates, and unless the parties consent, fee applications. Our probate division is up on the 3rd floor, but that is Chancery Court, 3rd floor of the city county building, but it is Chancery Court. The 3 chancellors and the main body of the clerk and master's office is on the 1st floor. But don't be confused by that. The probate court up there, even though it's referred to as probate court, is Chancery Court. Now, how do you get into Chancery Court? Let's not talk about probate so much. Let's just talk about general Chancery Court down here. How do you get into the court? Well, obviously, if you file a case and you represent a plaintiff or a defendant, you're going to be in the court. But let's say you don't have any cases yet, or you're in a firm and you want to get into court, but maybe you've not been assigned a case yet where you can, but maybe the partners will let you do a case if you can just have one, if you can find one. Well, you just let it be known to us. You let it be known to us that you want to be a guardian ad litem in cases like conservatorships, guardianships, termination of parental rights, and other matters involving children or incompetence. Or you let us know that you want to be an attorney ad litem and appointed for a respondent in a contested conservatorship or in a mental health case. Or you want to defend indigent defendants in parental termination cases, or where criminal contempt is involved, or where civil contempt is involved, but they might go to jail. Now, what do you do? What's the first thing you're going to do before you appear in Chancery Court? You're going to do what Judge Davis said, and that is read the local rules. And what's the second thing you're going to do? You're going to do what Judge Davis said. You're going to observe cases. And used to, before the virus, you could just show up in the court and you could just sit back in the gallery and you could observe cases. But now it's a little more complicated because of the lack of in-person cases, as in mass anyway. So you need to call us or contact us, and then we can maybe make arrangements where you can be socially distanced in the courtroom and you can observe cases. So you call me, or you call, well, maybe my assistant, maybe she'd be better known as my manager, Pam Jennings. Call Pam. The number is 215-2561. Now, before the virus came about, we had in-chambers hearings, or we had what we call an office docket every day from 9 to 9:30. But now with COVID-19, those cases we still have those every day, but they're done by Zoom or telephone. Those cases include uncontested adoptions, and Judge Davis had those, as well as adoptions in general, uncontested divorces, uncontested conservatorships, uncontested guardianships, minor settlements, things of that nature where there's no great adversity. where often there's no cross-examination at all. And this docket would be called our ex parte docket, and that's where a lot of the lawyer work would be done. The problem there is there's no way to observe them since they're done in chambers. So if you do want to observe them, and it's more difficult now with the virus, I'd have to have you call in advance. If you do call me or call Pam, we'll make arrangements so you can learn how to do those. Before the virus, all of the office cases were all scheduled at 9 a.m. and everybody just showed up in the hall or in the courtroom and waited until we called your case. And then we called them based on what looked best to call first, second, or third. But with the virus, the way we're doing it now, the cases are heard by Zoom or by telephone, and they're staggered at 9, 9:10, 9:20. So it makes it a little more complicated. Now, just call us though if you're a young lawyer and you want to learn how to do those, and because that's where a lot of the practice will be, especially if there's older lawyers sending you down to the courthouse or having to do one over the phone, but you've never done one before. If you want to get rid of that anxiety, we will help. Now, when you go into the courtroom itself, when we get back to normal, when you go into the courtroom today, you're still only going to go in there for one of two reasons. One of them is to do a hearing or a trial with testimony, and the other one's going to be to do a motion. Now, there could be a trial, I guess, just with stipulations, but I've never had one of those. Maybe Judge Davis has, where everything was totally stipulated. That'd be great, but I never had one of those. But let's talk about the motions first. And on motion day, and we have motion day every other Thursday. And motions include all sorts of pretrial and post-trial motions. Most of them are pretrial motions, and those would include discovery motions, like the local rule dealing with motions to compel that was referenced by Judge Davis. We have a similar rule. We also, though, if somebody objects, we have a hearing on it. Or dispositive motions, such as motions to dismiss or motions for summary judgment. And post-trial motions would include something like a motion to set aside a judgment or to alter or amend it or renew the life of a judgment. On motion day, everybody shows up at the same time still, but outside the courtroom. Before the virus, everybody would come in the courtroom. We'd all be in there together, and the cases would usually be called in inverse order of time that we anticipated they'd take. Well, with the virus, everybody shows up at the same time, at least at Chancery, but we only call in one motion at a time. So there's never more than one case in the courtroom at one time. Then when the case is called, of course, the movant, that could be the plaintiff or the defendant, goes to the podium first, then the respondent, then back to the movant. And most of the motions are decided at the conclusion of the motion arguments, but there can be times when they're not, when we take them under advisement. But again, there's no evidence on motion day in Chancery Court, except for maybe perfunctory evidence to support a motion for default judgment. But there's no round robin of witnesses on motion day. We can't do it because we might schedule 20 that day, and if we get off on doing testimony, we could get stuck at the first or second motion. These motions are argued pretty much along the same lines as what you may have experienced in law school with mock trials. You know, it may be that I'm talking to a number of you that have already argued motions, and forgive me if that's the case, but I feel like I need to cover the range because there's some of you that maybe haven't. And if you haven't, but you did mock trial in law school, you can handle a motion. When you come to the court for trials or hearings, used to, we called all the cases in the courtroom at once, and then we kind of did them the same way we did motions, who would take the longest, and also maybe whose case had been set the longest. If you were the only case, you could go ahead and set up, and maybe if you had a court reporter, that court reporter could set up. But not today, because we only have one case in there at a time for social distancing. So we will call you in there one at a time, but you'd still be out in the lobby and socially distancing, presumably. Where do you sit, though? You get your case call. Where are you going to sit? Well, in Chancery, if you represent the plaintiff, you'll sit to your right, my left, or the chancellor's left. And the opposite if you represent the defendant, to my right and to your left. And then the first thing that the chancellor is going to do is ask you if anybody wants the rule of sequestration. And if you do, then the court will give the rule instructions, but it'll remain your responsibility to make sure that none of your witnesses come in the courtroom and hear evidence. If they just come walking in, that's less likely to happen with the virus going on, but it used to happen quite a bit. Not all that infrequently before the virus. The bailiff will swear everybody in at once in Chancery, most of the time. And then if the rule was requested, the court will give the rule instructions that no one shall disclose to any non-party witness anything about the testimony or the exhibits until the case is over. Then we have opening statements, plaintiff followed by the defendant. Then the plaintiff's case, of course, the defendant's case. And the next closing arguments, just as you would anticipate from trial practice class. First the plaintiff, defendant, back to the plaintiff. But the main thing, though, is that most of the time, I started to say almost always, there's no jury. But it's a similar type format. And usually the chancellor will decide the case at the conclusion of the closings, but can take the case under advisement and decide it later that day or another day, issue a written or oral opinion, ask you to come back, or just simply send it to you in the mail. Hopefully it'll be within a few days and not months, where some of these cases can be pretty involved. All this is an oversimplification, but I'm just giving it to you as a general orientation. I know I would have welcomed any orientation when I was first starting out. The nature of the trials in Chancery, remember I told you that the Chancery really was born from the need to have persons do things that juries couldn't do. And so, as I've already alluded to, most of the cases in Chancery are not jury trials. In jury trials, the judges are conscious of not doing anything to prejudice the jury or to sway the jury. In bench trials, it's kind of the opposite. There is no jury, and therefore a lot of chancellors are more active than a jury. A judge will be with a jury. I know I'm totally different if there's a jury in the courtroom. So in Chancery, you can find chancellors asking questions during your opening statements, your closing statements or arguments, questioning witnesses, and maybe even expressing a concern or two, which would never happen with a jury sitting there. In the jury trials, the judge's orientation is more toward keeping improper evidence from the jury. And in your bench trials, in your Chancery trials, it's more toward letting improper evidence in, as opposed to taking the risk of keeping proper evidence out. So it's a little bit different. The judges are, well, maybe I shouldn't say this with Judge Davis here now in her new role, but they're a little, they kind of presume that the appellate courts will at least think that they were not not persuaded by any improper evidence. But we'll wait and see how Judge Davis is on that later. Of course, if the record shows that the trial judge relied on improper evidence, then of course he or she's going to get reversed. And when there's no jury, everything's a little more relaxed. But don't let the chancellor get by, though, without ruling on your objections, because it may be that we don't really want that question. We don't want to, have to address it. But if your objection is of value, don't let us just say something like, well, let's move on now, let's get going. Because there might be a tendency to do that. you'll need to say, I'm sorry, Your Honor, but may I please, just for the record, have a ruling on my objection. Don't let those objections go by. And strangely enough, I'll see this quite a bit. There will be a big argument over an objection. Then when the objection is overruled, the lawyer never asked the question over which we had the objection. So don't let that happen. You know, try to keep your focus going. Also, in bench trials, do not overlook the use of proposed findings and conclusions. There's some cases where they're required, like parental termination cases. And here we have to be careful that the judge or the chancellor doesn't appear to just simply adopt your findings and conclusions as his or her own without any independent review. But they're appropriate in other things too, especially in complicated cases where look at the judge and look and see, do you think that chancellor really understands your theory and is following what you've been doing? If not, suggest proposed findings and conclusions. And even in some types of cases, suggest that those be done before closing arguments so that the judge then can orient himself or herself and follow the theory of your case. Now, for general chancery court practice, the best book is Gibson's Suits in Chancery. Got text in it, and it has form. The 7th edition is the most recent edition. 8th edition is the most recent edition. For probate practice, Pritchard's on Wills and Administration of Estates. It has text and it has forms. There's text and forms for just about everything. But I think probably the most important thing, and I think this is along the lines of what Judge Davis was saying about watching cases, the most important thing I can tell you is to get to know your chancellor. I'm talking about Chancery Court. And how do you do that? First thing, look them up on the KBA web profile. And if you're in a firm, ask the other lawyers in the firm. And regardless of whether you're in a firm, ask other attorneys about the chancellors. In other words, get information. And secondly, as Judge Davis said, get to know the chancellor's assistants, the judge's assistants. You might leave a card for an appointment in Chancery Court, one of those that I discussed earlier. Now, while the virus is going on, it's more difficult to do. But so send us an email or maybe make a phone call, or a letter. But introduce yourself. Get someone in your firm or get a friend to bring you by to meet the chancellors, to meet the assistants. With respect to myself, with the virus, you won't get back here. But if you call, I'll come in the courtroom and meet you. And I think most of all the trial judges in this courthouse are willing to do that. I can tell you that trial judges are a lot friendlier than they used to be. And
Yes.
that is great. That's a great thing. Those trials and motions, again, don't hesitate to make arrangements to observe them with us. Don't hesitate to call us because of the virus. We understand that you can't just come in the courtroom, but you need to be able to observe them. And in learning about your chancellor, think about how important it is to be familiar with the faces of the members of a jury when you've got a jury trial going on. You watch their mannerisms, they're tuning out on you, or whether they seem interested, or whether one seems resentful, things like that. In Chancery Court, you've got a one-person jury, and you'll probably have that same jury panel for years and years. So it makes a lot of sense to get to know that one-person jury, to get to know that chancellor. And I can tell you that I really do. I look forward to getting to know you because I think for me and for Judge Davis and the other judges and the lawyers, you represent the hope we have for our legal system. So please don't hesitate to contact any of us.
If I can do it, just a quick follow-up on, I just want to touch briefly on motion practice in circuit court with the virus going on. It is different. And some people, even, very experienced lawyers, don't realize what we're doing with respect to motion practice now. As Chancellor Weaver mentioned, in circuit court, we are kind of the same as with respect to what we used to do with motions. I used to hold motion days every other Friday. So you would file a motion, the clerk's office would set it for a hearing, and then everybody would come in, and I'd have 15 or 20 motions on the docket for that particular Friday. So we're obviously not doing that anymore, and we have kind of changed pretty dramatically in the sense that we are not holding a regular motion docket anymore, like apparently you guys still are. Chancellor Weaver, you're just holding people outside. We're not doing that at all in circuit. So what we're doing now in circuit is, and you can find this new process and procedure on the KBA's website, and also under the Administrative Office of Courts website, which is tncourts.gov. But it has the basically pandemic plan for the 6th Judicial District, and it sets forth what each different court is doing differently now that we are in this new environment. But for motions in circuit court now, what we're doing is you file the motion. If it's not a dispositive motion, so it's not a motion to dismiss, not a summary judgment motion. If a motion gets filed, then the opposing party has 30 days in which to file a written response. After that time, the judge will take a look at the motion and the response, and the judge will make a determination about whether or not he or she feels there needs to be an in-person hearing on it. And if that's the case, then the judge's assistant will contact the attorneys, let you know that we need to schedule it for oral argument, and that's what will happen. And it's really easy to do that and maintain social distance, because most of the time the motions just involve 2 lawyers. And there's plenty of room in the courtroom, even if there's, multiple lawyers, there's plenty of room to space out and have that done. Now, it may be that the judge decides it doesn't need to have oral argument on it. And here's the key: the judge is the decision maker on that. If you think that you need to have oral argument on it, you can certainly call the court's assistant and let them know, and we'll take that into consideration. But ultimately, it's sort of like federal court. In federal court, you file the motions, the response gets filed, the judge makes a decision. Generally, oral argument does not happen unless the judge requests it. So that's what we're doing in circuit court now on motions. So dispositive motions are the same. The only difference is the time frame. Instead of 30 days to file a written response, you've got 45 days to file a written response. And then after that, the judge can make a decision on briefs without hearing oral argument. So be aware of that, because I know before I left, there were many circumstances where motions were filed and no response was filed. So there were some cases where I just, I had to go ahead and rule without having a response. And my concern was that the attorney may not have been aware of that rule, that they had to file a written response by a certain day. Because in the past, kind of their deadline, at least for non-dispositive motions, was the day of the hearing. A lot of times I would get written responses to motions. They would come in the day before that it was scheduled for a hearing, sometimes the morning before it was scheduled for a hearing, which I really just appreciated tremendously. But the fact that we don't have that date now by which you have to have your response filed, I'm afraid that might be tripping some folks up. And so I just wanted to make you guys aware to go ahead and pull a copy of that pandemic plan. Go to the KBA's website, print it off, and have it to refer to, because every court's doing it differently. Chancery is different from circuit, and circuit is different from criminal, and criminal is different from sessions. And so I would just encourage you guys to do that, so that you're familiar with kind of these temporary rules that we have in place for the pandemic. So I wanted to throw that in and make sure everybody was aware of that. All right, Do we have any moderators? Do we have any questions or anything you guys want us to address?
I'm not sure if anyone's typed in a question yet.
Okay.
I'd had some draft up, and I think Courtney might have some too. You want me to go first, Courtney?
Sure, yeah.
My first question is kind of, what are the best attorney practices you've seen on a motion hearing if they're up there arguing? Or is there anything that, really stood out when an attorney did it in either court?
I'll go and then I'll let you go, Chancellor Weaver. I think for me, I always read everything before you guys come in. So I am very familiar with the facts and with your argument. So I appreciated folks who kind of got straight into the argument part of it and didn't sort of beat around the bush. And you might ask the judge before you start, do you want me to go through the facts? Or do you want me to just start in with my argument? And well, I know Chancellor McDonald or Judge McDonald used to tell folks, and I got this from Judy. Judy said he would tell the lawyers when they came in, hey guys, I've read everything you filed, start towards the end. So especially back when we start getting our full motion dockets again, that's a long day. So I mean, I didn't want to sit there and listen to stuff that I already knew and that I had already read. So that's something to think about. But also something that I would strongly encourage you not to do is just to get up there and read your motion, read your brief, or read some pre-prepared statement that you've made. Motion days are a chance to have a conversation with us, and that's really what we want. We have questions. We may have questions. We may already know what we're going to do, but typically if we're asking you something, it's because this is a question that we have about this issue and we're not sure about it. And so for me, just being conversational about it and helping educate me maybe on why your argument's better, why this case is distinguishable, why the case that your opposing counsel cited does not apply. Having those kinds of back and forth discussions, I think it is very helpful, as opposed to just getting up there and just, giving a big rehearsed statement that you wanted to make.
For me, if the motion is complicated or unusual, motion briefs are very helpful.
Yeah.
And in summary judgment motions, the Rule 56 statements, getting those in timely, that's also very helpful. Not putting me on the spot of one side or the other calling for the disallowance of the other side's statement because it is untimely. But when you do file briefs, whether it be a trial brief or whether it be a brief in support of a motion, please don't wait until the night before or the same morning, because then I can't really read them. I don't have the benefit of them. There's a strategy I've often suspected that some of us don't want to file them too soon because then the other side gets it and is able to assimilate it and pick it apart. But I would much rather have that happen than not have the judge read it at all, which is what can happen if you file those too late. And I think also on motions, on some of them, if you're confident that the judge has got the background for the motion, understands the cases you're relying on, is to ask the judge just simply, do you have any questions about my motion? I know you've read it. Do you have any questions about it?
Yeah, let me follow up with that too. Along those same lines of not filing things the day before or, God forbid, the morning of, and it happens. It's not the end of the world, but sometimes we just don't have time to read it if you're filing it the morning of. And certainly if what you're filing is simply a response as opposed to a reply, that's going to irritate the fool out of me because you've had plenty of time, because motions don't get scheduled for the next day. If a motion is scheduled, it's been scheduled for a couple of weeks at least. So you've had time to get that in. But also, I would say if a motion is not going to go, if you've resolved it, let the clerk's office know that as soon as possible, so we don't waste time reading things that we don't need to read. For me personally, when I was over in circuit court, if I would have motion day on a Friday, I wouldn't start reading the motions and the responses until Wednesday, just because I knew that if I started them on Monday, invariably about half of what I would read, you guys would pull off, which is okay. Things get continued and there's conflicts. It's not a big deal, but if you can let us know just as soon as you can, that's helpful to us as well.
On the lines of letting judges know if things get pulled off, I've experienced this a lot since the courts have somewhat opened back up, but being scheduled in 2 different courts in Knox County at the same time, or in a short time frame, scheduled in General Sessions Court at 9 and Chancery Court at 9:30. What's the preferred way to handle that? In a perfect world, you'd be able to go to both, but it's somewhat out of the attorney's control.
Well,
Okay.
Go
Go ahead.
ahead. Go ahead.
Oh, the Zoom is so fun. You just never know if you're supposed to talk or not. Okay, I'll go ahead. So in my court, if you're scheduled in circuit court 1 and 2 at the same time, or you got to be up in Chancery Court, just let my assistant know, hey, I'm double booked, and I'll wait and see if you're in the courtroom or not. When I get to your case and you're not there, I know why you're not there. I just put it to the side and we'll wait till you come back. Let your adversary know that as well, so that they're just aware. So, but to me, that happens all the time. Just pick the one that you need to be in first. Let us know if it's not us, and we'll wait for you.
It's the same with me and with Chancery Court as well. Main thing is to let the assistants know what the problem is, because I don't know of any of us that would respond with, no, you'll be in my court first. I don't think that happens. I don't know of anybody that does that. There once was a time when that happened, especially between federal and state court. That's a war story I'll say for another time, but be sure it's legitimate. If you don't really need to be in the other court first, don't go there, just hoping that maybe it'll last longer there and this case will go away. Make sure it's legitimate, but be sure and explain it to the assistants first.
Thanks, guys. I think we got a question in the Q&A box. It says, Judge Davis, Chancellor Weaver, thank you for your advice. What mistakes and/or practices irritate you most in briefs or other written filings?
Chancellor Weaver, you want to start since I'm always starting?
Well, thank you, Judge Davis. Your Honor. I think overstating cases in a brief, that's probably the most offensive thing to me, is because I rely on what you say. I presume it's correct. I start reading it. I check it out, though, no matter how much I presume it's correct. My mother could have written a brief. I'm still going to check her out. But when I find that, no, it doesn't say that at all, then I think that's probably the most irritating thing for me. And then just in general practice, probably being late or not even showing up at all. That's terrible. Judge Davis?
Yeah, I agree with that wholeheartedly. I think be careful of your tone in whatever written submission that you provide to the court. Very rarely is being throwing your opposing counsel or the other party under the bus, accusing them of various nefarious things in your written submissions, generally is not persuasive to me. Just try and stick with the facts of what's happened and how that affects your argument. And I would say that as well in your presentation when you're making an oral argument. Keep in mind, we're not jurors. Sometimes we serve in that capacity when we are hearing bench cases, but being overly dramatic in your presentation, I think, is generally not effective with the court. We tend to see through that. We really just want to know, what are the facts, what are the law, how does it apply to reach the result that needs to be reached. So don't scream at me, please. People have done it, and I've had to tell them, you're yelling. You don't need to yell at me. You don't need to yell at your opposing counsel. You don't need to talk over each other. That is a huge pet peeve of mine, and it happens not infrequently on motion days. Is listen, everybody gets a chance to talk. I'm not going to deny you an opportunity to make your argument. So you don't need to jump up in the middle of opposing counsel's argument and tell me that you think they're wrong. I know that. I have a pretty good idea. That's why we're there, is because y'all don't agree on that. So just, everybody take a moment and be calm and be, in your presentation, just remember the difference between presenting in front of a judge and presenting in front of a jury.
I think one thing I observed, that you need to remain firm. Don't let the judge push you into a corner, but do not become overly firm to the point of unnecessarily antagonizing the judge. I have explained to lawyers before that, hey, there's three kinds of law. There's substantive, procedural, and the third one is persuasive. You don't want to antagonize the person you're trying to persuade. So there's no reason to do that. It really makes no sense, but it happens.
I think that's the only other question that was in the Q&A box. I guess we can ask you one more, and looks like we're running up on our time. I guess any advice for Zoom hearings would be my biggest question. Do you stand? Do you sit with the judge? The judge is sitting or standing. When you get up to talk to the judge, is there any type of procedures or advice you have for Zoom hearings?
Well, there's no need for you to stand up. That seems a bit unnecessary. Just do the best you can with the Zoom hearings. It's not ideal. Obviously, I don't think it's certainly not as good, and it's not effective as an in-person presentation. But remember, it is still a formal court proceeding. Just because you are in your home or in your office doesn't mean that, you don't need to adhere to normal court formalities. So in terms of your dress, obviously, please don't show up in pajamas or bathing suits. And other than that, just treat it like a normal hearing. It's a normal hearing. It's just in a different location, and it's virtual. So.
Yes, when the attire becomes too relaxed, like pajamas, things like that, of course, that somewhat discredits your presentation. I had one the other day where the lawyer, I don't think he meant to do this, but there's a lot of coat, the male lawyers don't wear coats as much. The female lawyers not quite as dressed as before. But this was really strange. The lawyer got up to get an exhibit and had a shirt and tie on, but just boxers shorts below that. I think he had forgotten. That is, just be aware of that. Don't let that happen to you.
That's a good note to end on. No underwear, please. In Zoom or in person.